Mede enchasonko ema daily trends etiefo enyina sabe daily trends da de bremu eno abia ena ene esande eba omangana nsem yensem no yenko na yenkuti ensem a ewo ho.
Viewers, something has happened in the criminal jurisprudence of Ghana today that has never happened before. Never happened. I'm not exaggerating. It's never happened before. So in criminal jurisprudence, one of the most important things is that an accused person has the case against the accused person has the highest standard of proof in criminal jurisprudence. The highest standard of proof is to establish something beyond reasonable doubt. Sometimes when we say this, people ask that, people think that every case is to be established beyond reasonable doubt. No. In criminal processes, the case against the accused person, the standard of establishing it, as far as what the court is looking at, the standard is that you have to establish it beyond any reasonable doubt. That means you have to establish it 100%. If you say Paul Ademochi has done X, you have to establish it 100%. If a doubt is raised so that your ability to establish it is dropped from 100 to 99%, the accused is free. You have not been able to establish the case against the accused. When you bring an accused person, they are not asking you to establish the case 40%, 50%, 60%. They want you to establish 101%. That is beyond any reasonable doubt. That's how it works. That is the law that we have inherited from Magna Carta, 1216 AD. Magna Carta, which is the Human Rights Bill. The main Magna Carta is in Latin. The main human rights bill is called the Magna Carta. You can Google it. Those people who like to Google, Gen Z people, Google MAGNA, Magna Carta. It's a Bill of Rights. Or you can Google the Bill of Rights to come. It was in 1215. Maybe I'm getting 12. Maybe it's 1237. Maybe it's 1220 something. But it's 12 something. Way back at the time Oxford University was established, this principle was established in criminal jurisprudence that where an accused person is being accused, first the standard of proof should be high. 1215. Yes, it's 1215, Magna Carta, 1215. I read it way back in pre-sec government, when we're doing government, A-level government. So sorry, I'm old, so when I say A-level, I know people can relate to it. A-level government, Magna Carta. We used to joke with it. Then we have nicknames. Some of the boys, we call them Magna Carta because they would chew the thing the whole night. Viewers, we learned, and we are happy that we did. So, Magna Carta is 1215 BC, yeah? And it's established the Bill of Rights. Okay, so in that Bill of Rights, it is guaranteed that an accused person should be allowed to defend himself with everything that he wants to defend himself with. So if an accused person says that the person who knows the matter that I have to tell the court is Mr. Paul Ademochi, he lives in London and he is not able to find money to come, the prosecution system, the court system would have to find money to bring Paul Ademochi down. For him to come and say the thing that the accused person says, it is only Paul Ademochi who knows this thing, and it is only him who can give this information to the court. If the court gets this information, they will know that I'm innocent. If that happens, the courts, it is an obligation on the court to organize for the said Paul Ademochi to come from England to come and testify. That is the extent to which the law goes to protect the individual. Okay, they are giving me disclosure. It means that I'm spending too much time on the introduction. I'll move on very quickly. So this is the matter. Atacha comes to court and says that I want a discovery. So there's because of this right that is embedded in Magna Carta, which runs through all criminal jurisprudence. Because of that right, when I say jurisprudence, I mean the body of legal theory that governs criminal prosecution. That's what jurisprudence means. You can Google that as well. Jurisprudence is a Latin word again. Juris means law, prudence means prudence, yeah? Okay. All right. So because of that, the law has granted an application called discovery. Now, the application called discovery can be applied by defense counsel, lawyers for the defense. That application can be applied by them if they feel that the material that they will use to defend themselves, it is in the possession of the accused person or the government. So, for instance, X is being prosecuted, like Kwame Boahen is being prosecuted, and then they've seized his passport. So his passport is at the CID. And then he says that I need the passport to be able to show you, not even that, that's not a good example. Kwabena Duboahen is being prosecuted, and he says that on this matter, Srem Sai cannot speak about it as Deputy Attorney General because that time he was in America. And then they say, yeah, Deputy Attorney General, you were not here, you were in America, so why are you speaking as if you were here? He says, I was here. They say, no, you were not here, you are lying. Now his passport is with him. It's not with me, it's with him. Now, the process of discovery allows the accused person, the lawyer for the accused person, to apply for discovery and tell the court that compels Srem Sai to bring his own passport to the court that we can ascertain this matter. That's what discovery is about. So discovery recognizes that the accused person may need some material that is in the custody of the prosecution, who are more powerful than the accused person, and therefore the prosecution does not have the power to go and search accused person's house. They don't have the police. The defense does not have the power to search the prosecution's house. The defense does not have police. They don't have immigration. They don't have CID. They don't have airports. They don't have anything. They just have themselves and the law. So the rule of discovery is that where the defense counsel, so emasculated by their role as defense and their hands are cut off, that's what I mean by emasculated, they can apply to the court and tell the court that this material, it is in the hands of the prosecution. They should bring it. Because the prosecution will now be asked to bring something from within their fold that will be used to challenge their own case. So they may be resistant in doing so. So the legal system brings about the rule of discovery, that counsel can apply for discovery that this person should bring it so that we'll use against him. With that background, let's look at the meaning of discovery, and I'll show you what has happened in the Court of Appeal today. Black's Law Dictionary's 4th edition says discovery means the disclosure by a party of facts, titles, documents, or other things which are in his exclusive knowledge or possession and which are necessary to the party seeking the discovery as part of a course or action pending or to be brought in another court or as evidence of his right or title in such proceedings. It's written for lawyers, so don't worry about the repetition and the punctuations that are made to settle everything. So that's discovery. The learned counsel for Kwabena Duboahen, Atachia, was shocked to the bone and marrow when he found out that a bank statement, and you know this Kwabena Duboahen thing is about banks, a bank statement has been brought to the court by prosecutor Srem Sai. He brought a bank statement to the court. When he brought the bank statement, about 70 pages of the bank statement had been taken out, and he brings bank statement of only page 2 to the court. And then Atachia says, but I've not seen some of this before. What is the meaning of this? Where is the rest of the bank statement? Because we need the rest of the bank statement to make our case that whatever allegation you are making is unfounded. So long as you can produce the entire bank statement, we will show the court. Srem Sai says, I can't give you the entire. How do you bring a bank statement from Advantage company, Kwabena Duboahen's company? You publish their banks. You know that he's the owner. He also has a bank statement. But you publish the bank statement in the court, and you publish only small and leave the rest. I mean, viewers, how callous can people be? How wicked? You want to by force jail the guy, and you think you have the courts. By force, they want to jail him. Because how do you explain this thing? And that's why it was useful for an application to go for this trial to be shown on television. As for this Kwabena Duboahen trial, it pains me that it's not on TV. It should have been on TV for everybody to see the disgrace and the embarrassment that is happening to our local jurisprudence. It should have been on TV for everybody to see. How do you say that an accused person cannot be entitled to a bank statement, the full bank statement, but you only want to bring 2 pages? Atta was beside himself with anger. The judge said Atta can go on with the case. He doesn't need those bank statements. That's the judge's opinion. Atta was outraged. He filed to the Court of Appeal. This is a high court trial. He goes to the Court of Appeal where 3 judges are looking at it. And again, that's how the jurisprudence has been set up. 1 judge at the High Court, 3 judges at the Court of Appeal. So if you don't like what a High Court judge has said, there will be 3 other senior colleagues of his to look at it for you. And if they look at it and they agree with him, then you know that you are getting out. If they
for you, they could have given Ghanaian the civil society organization in 1 month to say
they did though.
Amendments.
Yes, they did.
No, the MPP is making an allegation say Emrana Edahona ne was almost signed. To parliament, it has been diluted and many has been removed and many have been amended. Civil society organization amended ones about
there was an engagement. Say Grace Bepe video na maya. Obakaya, there was this engagement via no more ya. Sam George, not Sam George to say. And another Reverend John Tim for also to say. And they had some discussion be now lawyers or a round table discussion.
And to me, and you not to send here. Were we privy to say amendments until that day?
Oh, Akuta, who said now? Omufi said Emrano. Very
good.
And at the second
now,
time,
the bone of contention is Kitwana Ninkakrana Yifri Munako. And you know, again, Moshem Ramai, Moya Bako, Omampania and Saint Musi Egu, and a Moko Farm Rano, and a Muya Fufro. Since Sayabe Mua, we ought to know. You don't pass the law for me to know somebody in society. Because
all this week, it doesn't make Emrano illegal. It doesn't make Emrano. I say Emrano.
It's like it's a funtus official.
Yes, I said in Komona Yedino, the president didn't there. Because parliament has started. Omo kana say yanyen ye inti yankotonchine. No, Nico say omo dia caught that point in the cry. Second time a day. I didn't want to what's up. About my excuses. Window be near from other Trumuna a day.
Okay, as I
could tell last for her, Sir President Mahama one science. I do know so a campaign about me be deputy president. That's all. Sir President Mama and sign Sab Bill no Modia Kwakotun and Nimna. Straight away, President Mahama a campaign about me, Sabao me be president. Asa.
Okay.
Marano. In all entirely, it's more palliative. Who's a missing kind of yes, yeah, the dodo, said the moment this answer.
Yes, so.
You can go iron cost. Hey, oh, can many in a social media and say 3 to 7 months. We in fact, you should be cool when you be good. When they make okay, Uganda, man, now, almost first one. Yet you are a name punishable by death or life imprisonment. Wait, it is a Emma say obey. I say murder. It has been attributed to the same equation as a murder offense. Okumobi. The issue would say obi who so be give meka. Doctor and the so commit me because doctor dear. Me a doctor me jo nkwa. Me hu so yes I do ni kwa say mbabeka. Eno de nka ho. By any other person me tifie na me de obi tifie me so ye se bitumutumu bia. O so go catch police for. I say obi na
say ye free mo.
Aha, obi a wokum nipa. Wo so obi tifie obi a criminal wokum nipa. Na o meka. So the law no nanka ni equation level na say murder situation na but on my ohwe mra no a say the tofa bo nyina na baby kura na o mo say obi nya kwan propagate enka sa emfa ho no kra so edufu se mba kokra
eno kra na asante chesesi a no kane no na se ka wo betena TV so na wo bo gay na se wo bo ho dawuro se eyade pa 3 to 5 years so 3 months to 5 years chesi a ye free mo ya mendino it is say asante me wa no permit ma betena every morning
and that is
na me propagate yaw gayism
and if so
obi da to anya bone obi antimi nchimi o
emrano die yanhwe ya events much ado.
Yes, they are calling for more of advocacy.
Oh my tie baby na okay say ya pass emre bia wo pass ya it goes against people's rights biano. We do consultation. First of all, ROPA and DOPSI, sir, domestic violence support unit in Mrano. You go around the whole country.
Yes.
President Fompany for digital, lawyer for digital, social activists digital go around the whole country. Eko G amount for adjoin for home. But where there, meeting at the Reverend meeting for your time and say, you are at a privileged position. One program who say amendment when I go. Our mama he has to train. Na ye a job on table.
Na me dey asante dey emsre kra ni o. Obi or dressing in a manner that depicts them as people of the opposite gender or up to 7 years in prison. You see our man amending the say. So utimi kire say watade na wo share. it has nothing to do with gay there me mo ahye go prison na why na be sha atade a obechi na obeka say be gay ntina me sha atade
only reason
what is this
omu konkan baby ko ese obakwabra pa ahihye ayi mama okui bi ayi kan more sabi we enye
what say week ni ade obe jira kwa ho ye wo emema obe jira kwa ho mo yonko mema de ka be fa omo
sabi is a phone
okọ wi ne to
na okwachi we okọ yakobi obi to no eni ko jira court say ada aje ada ko 2 to 7 months emma de nyame no mekoni eye soso mra
na portions bi o esi fie wura kra odu fie be ma han ye beba be hu se
o ma ye free
na akotenti sa mra wi ne nka kufa do ngo
o man eye boa because
u fie fie wura akota me di fie ama asante boa han na me de me ko aduma na se o do be se o ma o se
ko aduma hwe sadia we neighbor
fie wura de no de o mbe so o mo kire se
u fie wo se pa for this phone
but wa wuru se enema ekoso ni suban ekoso assure within the community say abrantie ni na abrantie ababa we ni ababa o mbehye wa sa nema no ye ebi awani ehu ana wo wa nyi asutire ni wa mana koso so it's like you are aiding and abetting
barakota eno soso de obi ni obi ye woni dem
eno soso ya samsa
medem
o ya we eye no kwese de obi ni obi ye woni dem
ko ha ye gina ya ha dan wan na ha dan ye ufie wa omusa so ye adwuma be ko ha dan ufie wa omusa se catch we ye adwuma be they do these things joking obusa na ye adwuma be ebia so they do those stuff but what busa me twa ntra say me
abranche no be wura house
madam funo no minua no
anya se bia ya wo bia na wakotete ho beti bi ho
akuta eno so kwa me busa no so da bi ebia me sisi ya me ya eno mi ya akuta ya certain things what they call say fever kwa sa
o se mema mienu esa antibom up and down se bo mo so mo nsem funo mo do tan no
as ebu okra wanim no mu kisi ya woni de uma na ba yi ni nyina free mo se si amra na o si
me de amra ni de on parliament mo
say omu protect the gay community more than
some punishing them
we amra oh yeah we now no there ase mo
pemra ni ya bia mamu
ase mo se mo pe anti gay bra
and ya
mamu bra na mo benya si apase eti akwa say ya pass ba ukomu a hwinim sana kwesi
3 to 7 months the maximum punishment
there
is no punishment
and we can only on my
amwa 2 years na me call 7 months ba
amwa
the be party grab
on my way we can me who say we can game for no kwem mo kire say who person on say game for no mo ntimi siki asylum in the United States and other countries so mo just animal we tum but say ko ba say ko dem 3 to 7 months per dia say we dey nya dey say US for how mo say on the grounds of homosexuality ye ma ba ho because we dey ye insist ye ntra obi afa ho jesu we dey o ntimi mfa nkosiki asylum ye nti o man media parliament man dey become Friday no